My special guest tonight is Phyllis Schlafly. I guess if we had to point to one thing, Phyllis Schlafly changed America by changing the vote on ERA. Gerald Ford was in favor of the ERA. Richard Nixon was in favor of ERA. George Bush was in favor of
Jimmy Carter. Don't forget him.
The president at the time. I mean,
well, it is
you
true.
Had a lot of windmills.
We showed that individual American citizens who do not hold public office and who don't have a big bankroll behind them or own a newspaper can affect public policy. And I think that's very exciting.
Her movement, and her movement alone, against the ERA, managed to halt all of the momentum which had been created. Her arguments were based on traditional notions of the roles of men and women, and appealed to very many people, so many so that it halted the feminist movement in its track. The amendment itself was very short. In its entirety, it stated, "Equality of rights, under the law, shall not be denied or abridged by the United States or by any state on account of sex." For my research question, I will investigate to what extent is the failure of the Equal Rights Amendment due to traditional discarded notions of femininity. I'd like to keep in mind here that while many of these beliefs will definitely be traditional, we're trying to establish if they're also discarded within our current society. Let's see what the woman who brought it down has to say regarding why her movement gained so much momentum.
On the other side, if I had to say the real reason why the ERAers lost is that they don't have a product to sell. There's nothing good that they can point to.
It's important when we look at the Equal Rights Amendment that any case against it was entirely theoretical. The fact is, any of its impacts post-implementation were debated by legal scholars extensively, but since we never actually saw it put into law, the more important aspect of the Equal Rights Amendment debate was the way it changed Americans' hearts and minds, and not any real impacts that we could point to. Because of this, we'll analyze the public perception of Schlafly's arguments more than their accuracy. So let's begin. The first argument Schlafly presents is with regards to the fact that both men and women would be subject to the draft. At the time and today, women are not conscripted in times of war, and Schlafly argued that women and men would be drafted without considering their sex or familial role. For instance, if a woman had just given birth or was breastfeeding, she would still qualify in the exact same way as the father did for the draft, because they were both qualified exclusively as parents. The fact is, her argument was completely accurate textually, and no one she ever spoke to could argue with the fact that this would be one of the impacts of the Equal Rights Amendment's implementation. This created a lot of fear in family units with newborns and young children, because in the event of a war, this would mean that there would be no legal difference between the roles of the mother and the father. This meant a wife could be drafted with the same frequency as her husband. Schlafly argued that since women had on average less muscle mass and were less prepared for war, that this only increased the probability of one of the children's parents being killed or injured in war as well. As said before, this was definitely one of Schlafly's more persuasive arguments. The thought of young daughters and mothers being pulled out of school or of their homes to go fight in a war terrified a lot of people. So, is this argument outdated? Just from the presumption that women would be weaker wives and the person who would watch over the children on average, one can already tell that it is definitely a traditional notion of femininity. To determine if this belief was a relic of the past, I asked some people from my community. Do you think women and men should both be drafted?
Yes, I do.
Yes, I do.
Do you think they should be drafted in equal numbers?
I think, yeah, by percentage. Yeah, definitely.
Yeah, I think so. Yes.
Okay.
I don't think anyone should be drafted.
But say if they were.
Then yes.
Do you think...
I think, actually, I don't... Sure. I mean, like, what if a woman, like, just gave birth and it... I feel like, yeah, or if she's already a mother, I feel like especially for infants, like it's more important for the mom to be in their lives just because of like biologically than a father.
As you can see, from the pool of Berkeley High students, most came to the consensus that yes, women and men should definitely both be drafted. However, we have to keep in mind the pool of people we're interviewing, and for this topic specifically, it's hard to determine if it really is outdated. Many people believe that Perhaps women shouldn't be drafted in equal numbers, but should still be drafted. Either way, a poll from the Hill found that most women still oppose registering for the draft, with only 38% in favor of it. However, 61% of male respondents thought women should register. This means generally 49% of people support drafting women, a fairly significant shift from the 1960s mentality. Schlafly's second argument was probably one of the most persuasive. She argued, and no one ever truly had a legal contradiction, that there could be no single-sex locations if this amendment was passed. This includes schools, bathrooms, and most importantly, prisons. All female colleges, for instance, would be required to integrate men into the schools as well, along with all private single-sex high schools and elementary schools. Obviously, this argument became extremely popular in the social mainstream. Very quick trigger warning. The thought of mixed-sex prisons specifically was shocking to most, given the frequency of rape just within all male prisons, and especially when one considers that many of the men are in there for crimes of assault and domestic violence. This was one of the main reasons that the amendment, at the height of its popularity, ultimately failed. So, to gauge if the mentality had changed since the 1970s, I asked some of my classmates the most provocative and legally sound arguments Schlafly made regarding mixed-sex prisons. Would you be comfortable having mixed-gender prisons?
No, I think with the way that prisons are so unregulated and overcrowded as they are, that could only lead to issues.
Yes.
I don't know.
No, I don't think that is necessarily the best idea.
No. Okay. But I'm also not comfortable with male guards in female prisons, so.
As one can see, this question generated very different responses from my classmates. While the former question was significantly less provocative, people understood here that integration of men and women into the same space in a very violent, hostile location could result into some very bad situations occurring. This is the same mentality that was demonstrated in the 1960s and 70s from people who heard Schlafly's argument, because they realized the sort of dangerous situation that could result from mixing these two groups. Finally, the last of Schlafly's central argument was with regards to Social Security payments. This argument is significantly more complicated than the others, and it resulted in a lot more legal arguments with regards to possible future legislation. The crux of the argument was that at the time, in all states, when a husband was working and a wife wasn't, if the man paid into Social Security through the FICA tax on his income, that's a 6.2% tax on the income, he receives Social Security benefits not only for him, but for his unemployed wife as well. However, at the time, many states did not allow this to occur in the event a wife was working and the man was not. This meant that if a wife wanted Social Security benefits, she had to pay twice on Social Security taxes, 12.4% of her income. Schlafly argued that if the law changed to regard women and men as exactly the same, this would result in everyone who had an unemployed spouse who wanted Social Security benefits for them both having to pay twice on Social Security taxes. The truth of the matter is that this is one of Schlafly's weaker arguments, and it's based on the fact that one wouldn't want a wife working. It's weaker because the Supreme Court had already ruled, and many states had legislated, that they would give benefits to any unemployed spouse regardless of sex. However, many people at the time believed her argument. So I asked a group of my classmates again what they thought about this argument, despite the fact that asking a group of 17 or 18-year-olds about income taxes seemed like it wouldn't exactly yield very informative results. Would you be okay with paying twice on Social Security benefits?
I think I would be able to answer that question better when I'm a working adult.
No. Yeah.
Yes, 100%. And I think people who make over $1 million should be taxed 90%.
Fair enough. As one can see, for the people who understood the exact nuances of the argument, they didn't want to pay more taxes. However, many people thought that this was a worthy sacrifice. Either way, it's very hard to gauge what real people would think about an income tax if one is exclusively relying on asking people who don't pay an income tax. Nonetheless, today, all states allow an unemployed spouse, regardless of sex, to receive Social Security benefits from their employed partner. Clearly, this was the most popular change which benefited all people, and the vast majority of people support this measure. Schlafly's argument here clearly fell short with regard to the concept that the state should provide Social Security benefits only to households with unemployed women and not ones with unemployed men as well. Everyone wants to get more benefits, and Schlafly's argument resided on the fact that women should be in the home and that the government should encourage that. At the end of the day, many of Schlafly's arguments stand today, and as the government increasingly tries to grant women advantages in hiring in terms of affirmative action and other pro-female efforts, the shift in the societal mentality is definitely still not in favor of the Equal Rights Amendment, but towards laws which give extra benefits to women to compensate for societal discrimination. If one needs any more evidence, we can look to the fact that only 32 states officially have passed the Equal Rights Amendment today. Although there is still a clear change in public sentiments towards the Equal Rights Amendment, the more important change comes from the fact that the amendment's passage has much less opposition because of discarded notions of the traditional roles of women. However, there is still a significant enough opposition to the amendment because of the maintenance of the perception of women as deserving single-sex locations, especially with regards to prisons.